Greetings, everyone, and thank you for joining us for this third webinar in a series. So the title of tonight's webinar is Indigenous Rights in East Asia, Current Struggles in Japan, China, and Mongolia. This webinar follows previous two webinars that respectively dealt with Oceania and then South Asia. For tonight, we're focusing specifically on three countries within East Asia, Japan, China, and Mongolia. And the goal is to educate audiences about the various indigenous rights movements in these countries and the current approaches within these countries regarding the discourse on group identities and indigenous rights. This webinar series is co-sponsored by the Australian National University School of Law, the American Society of International Law, the Harvard Law School Human Rights Program, and Law Asia, which is the association of legal practitioners in the Asia Pacific. My name is Jonathan Lollyblad. I'm the associate professor at the Australian National University School of Law, and we are joined tonight by four esteemed speakers, and I will introduce them individually as they make their presentations. In terms of opening, here in Australia, we practice a welcome to country for each formal event. And it basically goes like this. We acknowledge that here, in particular, at the campus of the Australian National University, we are situated on the traditional lands of the Ngunnawal and Ngambri peoples. We pay our respects to the elders, past, present, and emerging. And we call upon all of you in the audience, as well as the wider world, to be cognizant of the issues of Indigenous peoples and the ongoing struggles regarding Indigenous sovereignty. Now, myself, I'm a member of the Indigenous peoples called the Pa'o, which is an Indigenous community in Burma and Myanmar. And then tonight, we also have Indigenous speakers. The running order for tonight is that we will be discussing Japan first, and then we will be having a discussion, a second of Mongolia, and then last we will be discussing China. In terms of the questions and answers, we will have the presentations first. So the bulk of tonight will be the presentations from the speakers. However, for members of the audience who do have questions, we would ask that you place your questions in the chat space in the webinar chat. And then that way, all of the speakers can see the questions as they are making presentations, and they can prepare, the speakers can then prepare their answers. We welcome all questions, and we look forward to seeing your questions in the chat space. The first presentation tonight is with respect to Japan, and for that country, we have two speakers who will be co-presenting. The first speaker is Dr. Kanako Uzawa. She is an Ainu scholar, artist, museum curator, and advocate for Indigenous voices worldwide. She is the founder of Ainu Today, CEO of the K. Uzawa Consult. She is also assistant professor at the Global Station for Indigenous Studies and Cultural Diversity at Hokkaido University and an affiliated researcher at the Historical Museum of the University of Oslo in Norway, as well as a member of the working committee of the Upopoi National Ainu Museum and Park Management Council. She holds an MA in Indigenous Studies and a PhD in Community Planning and Cultural Understanding from the UiT Arctic University of Norway. And as an artist, Dr. Uzawa has performed internationally, including the Cultural Festival of Bodø 2024 in Norway. And as well, she has also been a visiting artist in residence at the La Trobe Art Institute in Australia, the Banff Centre for Arts and Creativity in Canada, and the Swedish National Theatre. She is currently also a guest curator at the University of Michigan Museum of Art and the National Museum of Lithuania. The second speaker is Professor Yuko Osakata. She is a professor of international human rights at the Chuo University Law School in Japan. She holds a PhD from Kyoto University, and her research focuses on the effective implementation of international human rights, particularly the rights of Indigenous peoples, and also decolonization in legal studies. She is committed to advancing international human rights for minority groups and as well for Indigenous peoples. So, Dr. Uzawa and Professor Osakata, I will turn the time over to you, and please feel free to go ahead and start your presentations.
Thank you so much for the very kind introduction, Professor Liabran. I will share my screen now. One moment. Yes. So, ilang karate, that's the greeting in Ainu language, which means let me touch your heart. It's just little more than hello. And many of you may not heard about Ainu people, so I just like to start um, introducing who we are. Ainu are indigenous people of Japan, primarily from northern island of Hokkaido, as well as a part of Sakhalin, now Russia, and the Korean island. We have a distinct language, culture, spiritual beliefs that are different from majority Japanese population. Traditionally, the Ainu were hunter-gatherers and fishers, living in close connection with nature, practicing ritual to honor animals, plants, and spirits. Just give you a background, during the late 19th and early 20th century, in the Meiji period, some anthropologists speculated that Ainu people might have European or Caucasoid origins. These ideas, particularly influential in Germany, reflected a broader global trend in physical anthropology that classify human populations much like plants and animals. This period was also shaped by social Darwinism thinking, which ranked human society hierarchically. Within this context, Ainu, human remains, burial artifacts, and material culture were collected by anthropologists, travelers, and tourists even. Sometimes purchased, but at times taken without consent from local individuals. And this picture, Dr. Malo is a very known physician in the community that I'm from, or my mother is from. And he even collected some of the Ainu human remains, and which have been now returned this year to the Ainu community. So this is the map of Hokkaido, and I have marked Nibutani community where my mother is from. And Nibutani is a small community of about 400 people, surrounded by nature and rich cultural and historical significance. For me, it's both a place to return and the home of my heart. The memories and lessons from my childhood spent in my mother's hometown continue to shape my work today. Now I'd like to talk a little bit about the Nibutani Dam case. Nibutani Dam case was a landmark moment in the struggle for Ainu rights in Japan. The Japanese government constructed a dam on this Sado River in Hokkaido with a stated purpose of flood control, securing water for municipal industrial use. In doing so, however, it failed to adequately consider the Ainu people's deep cultural, spiritual, and ancestral connection to the land, including sacred site and traditional livelihood that are submerged by this project. Two Ainu leaders, Kayano Shigeru and Kaizawa Tadashi, who is my grandfather, and later his son, Koichi Kaizawa, who is my uncle, filed the lawsuits against the government, arguing that the dam violated indigenous rights, particularly those related to land and culture. Excuse me. In historical ruling, so the Sapporo District Court officially recognized the Ainu as indigenous people for the first time and criticized the government for failing to respect our rights under Article 27 of International Covenant and Civil Political Rights and Article 13 of the Constitution of Japan. The case became a major turning point in raising awareness of Ainu cultural rights and influential subsequent legal and policy developments. My own family members were plaintiff in this case, as I mentioned, and I witnessed firsthand how my grandfather stood up for this fight and emotional and physical toll it took on him. For me, this Nibutani Dam case is not only legal precedent, but also deeply personal history. At the same time, this moment helped inspire, empower the young generation of Ainu, including myself, to travel overseas, present this case within global indigenous forums such as the United Nations, situating the Ainu struggles within the broader international movement of indigenous rights. Although the dam was ultimately completed, Nibutani Dam case remains a powerful symbol of resistance and of ongoing efforts of Ainu people to protect our culture and land and wildlife. So this is a picture of from the Nibutani community, and this is a house called Chise, just to give you some idea. From the late 19th century, Japan modernized rapidly during the Meiji period and pursued policies to assimilate indigenous people. The 1899 Former Aborigines Protection Act, presented as a welfare, actually took a Ainu land, language, livelihood, forcing them into farming and Japanese way of life. By the 1980s, Ainu activists grew. In 1986, Prime Minister Nagasone called Japan ethnically homogeneous, ignoring indigenous people. This encouraged Ainu leaders to speak out internationally. In 1992, Giichi Nomura, who is a representative of the largest Ainu association in Hokkaido, told the UN General Assembly that Ainu are living people facing discrimination, not a banished group. These efforts helped gain a later legal and cultural recognition and inspired younger generation, including myself, to engage in global indigenous movements and shape Ainu history and rights worldwide. And just to, I have, time is running out, so I just want to show you this. In 2007, the government voted for the UN Declaration on the Rights of Indigenous People, and following year, 2008, when we had actually G8 summit in Hokkaido, government recognized Ainu as indigenous to the land of Hokkaido, and later, 2019, we were legally written in the in this new law. So, from these defining moments in the 1980s and 1990s, Ainu movement has continued to grow, laying the foundation for today's cultural revitalization. Nibutani Dam Court ruling in 1997 and the Japanese government recognition of the Ainu as indigenous people in 2008 and 19 marked further turning points. Now in 2025, Ainu communities are actively reclaiming language, art, and traditions, while shaping new forms of expression in education, film, performance, and digital media. This revitalization reflects not only resilience, but also a forward-looking determination to ensure Ainu culture thrives in present and future. if you are interested in the Ainu people, these some of this is my website where we have listed a number of literature, both academic and for more of a general public, and also this is a country report that I have written. Thank you so much. いやいだけで。
Hey, thank you, Jonathan, for your kind introduction and also for organizing this meaningful webinar. And because of the time limitations, I'm starting to make a presentation. And mostly I will talk about the current legal situation of the Ainu and its problems. The Ainu Policy Promotion Act. So 9 months after the adoption of the UN Declaration on the Rights of Indigenous Peoples and Rape, both houses of the Japanese Diet unanimously adopted a resolution calling for the recognition of the Ainu as indigenous people on June 6, 2008. In response to this resolution, the same day, the Chief Cabinet Secretary announced the government's official position recognizing the Ainu as an indigenous people of Japan. This recognition was later codified in domestic law through the so-called Ainu Policy Promotion Act. However, so far, the Ainu have not been recognized any of the collective rights proclaimed in the Antwerp. So, what is the Ainu Policy Promotion Act? The Act recognizes the Ainu as an indigenous people of Japan for the first time in a law. The Act also stipulates the prohibition of discrimination against the Ainu, the responsibilities of national and local governments to deepen public understanding of the Ainu, a subsidy system for local municipalities aimed at promoting Ainu-related measures, and special consideration for granting permission for salmon fishing in rivers, among other provisions. According to the Act, the meaning of the Ainu culture is broader than that defined in the Ainu Culture Promotion Act, the former law. The term now includes the way of life of the Ainu. However, the Act does not contribute to promoting the Ainu way of life, but rather focuses on traditional Ainu culture. Against this backdrop, the Rapport Ainu Nation, a local group of Ainu fishers in Rahoro, Hokkaido, brought a case before the Sapporo District Court on August 17, 2020, asserting their right to conduct commercial salmon fishing in their local river, the Rahoro Tokachi River. So the next is about the Rapport Ainu Nation's lawsuit. The Ainu relied on salmon as the staple food, and it was the most important fish caught in the rivers. They also used it for clothing and trading. The Ainu hold the salmon in high regard, calling it the divine fish. However, since the Meiji era, local governments have gradually banned salmon fishing in rivers in the name of environmental conservation. A general prohibition on salmon fishing in rivers still exists nationwide. In Hokkaido, there is a limited exception for the Ainu. Those who obtain permission from the Hokkaido governor may fish salmon only for their traditional ceremonies and transmit their traditional fishing methods. However, some Ainu people consider such a limited exception to the sweeping ban insufficient and have challenged these regulations. The Rapport Ainu Nation's lawsuit presents one such challenge. The Rapport Ainu Nation's legal claim is based on its native title. However, as native title have not been recognized either by national or local governments or by any Japanese court, they granted their legal arguments primarily in international human rights law. Their advocacy was actively supported by international human rights law scholars, including myself, through the submission of expert opinions to the court. On April 18, 2024, the Sapporo District Court handed down a decision against the Rapo Ainu Nation. So this is the first stage of the case, and now the case is pending at the High Court, the second stage. So the following is a summary of the District Court judgment. Considering Article 27 of the International Covenant on Civil and Political Rights, ICCPR, the court held that they were recognized as having the right to enjoy their unique culture in accordance with Article 13 of the Constitution of Japan, the individual right to pursue happiness. The court also stated that as the fishing rights claimed by the plaintiffs exceed the scope of transmission and preservation of traditional rituals or fishing methods in terms of its purpose and methods, it has a strong aspect of property rights. The court applied the criteria to judge the legality of the restriction on property rights under Article 29 of the Constitution of Japan. Article 29 states that legislature may regulate property rights as long as they are compatible with public welfare, taking into account the interests of society as a whole. The court did not find the violation of any river laws, saying that establishing the right to fish in rivers is a matter of legislative policy. So, because of the time limitation, I will make it shorter, this part shorter. But this decision was problematic from the perspective of international human rights law. The court distinguished between Ainu salmon fishing for ritual purposes, which is protected by Article 13 of the Constitution of Japan, and commercial fishing, which is mainly protected by Article 29 of the Constitution of Japan. The court applied lower criteria for the latter, thus decreasing the Rapo Ainu Nation's chances of success. In contrast, the UN Human Rights Committee, the monitoring body of the ICCPR, has stated the reindeer herding of the salmon constitutes a culture protected by Article 27 of the ICCPR on the basis that such economic activity is an essential element of this ethnic community. Given that Ainu traditionally used salmon as trading commodity, the commercial right to salmon fishing as an economic activity has historical significance for their cultural traditions. Consequently, it is impossible to distinguish between commercial fishing and salmon fishing as a cultural tradition. From this perspective, the Ainu's rights to commercial salmon fishing should be firmly guaranteed as a cultural right under Article 27 of the ICCPR and should be treated as a right under Article 13 of the Constitution of Japan, not Article 29. So this is the last slide. And even if the Ainu's right to commercial salmon fishing is considered an element of property rights, it should be treated differently from regular property rights under Japanese civil law. This interpretation was based on the opinion on the Committee on the Elimination of Racial Discrimination in another case of the salmon reindeer herding. Here, the third stated the special consideration from the perspective of importance of indigenous economic activities for the culture is required when limiting indigenous property rights based on international human rights. So there are more criticisms of the court ruling from the perspective of international human rights law, but as time is up, I'd like to conclude here. Thank you very much for your kind attention.
So thank you, Professor Osakata, and thank you, Dr. Uzawa. That was a very interesting introduction to the situation in Japan with the Ainu. Next, we are transitioning to discussion of Mongolia. For tonight, we are focusing on the nation state that is called Mongolia, even though Mongolian peoples extend outside of those borders. So on the topic of Mongolia, we have tonight Dr. Narantunya Ganbat. She is a commissioner of the National Human Rights Commission of Mongolia, and she leads work on civil and political rights. We are proud to say that she's an alumnus of the ANU School of Regulation and Global Governance, where she received her PhD, and also where she is a visiting fellow. Her research focuses on human rights institutions, treaty systems, and protections for vulnerable groups. And so I will turn the floor over to Dr. Ganbat. So thank you.
Thank you, Jonathan, for the kind introduction, and thank you very much for the opportunity to speak today. I shared my screen. Is it showing? Or okay.
We can see it. Thank you.
Okay. So, okay. Oh, okay. So before I begin, I would like to make 3 clarifications. First, I want what I present today reflects my personal and academic view, informed by my work and research experience. So they don't represent an official position of any institution which I am currently affiliated, especially the National Human Rights Commission of Mongolia. Second, this presentation is strictly limited to the territory and the population of Mongolia. I will not address Mongolian population living in China or the Russian Federation, whose cultural, political, and legal contexts are fundamentally different. Third, I would like to be clear that I'm not an expert in indigenous rights, indigenous people's rights as a specialized field. My analysis draws on general international human rights law, institutional practice, and Mongolia-specific evidence, and is offered as an academic reflection rather than definitive interpretation. So why indigenous rights is a complex question in Mongolia. Mongolia is a vast landlocked country with harsh continental climate and one of the lowest population densities in the world. The current population of Mongolia is 3.5 million. Historically, Mongolian society developed through mobility, seasonal land use, and pastoralism rather than sedimentary agriculture. Like many countries where indigenous rights debates emerged from overseas settler colonialism, Mongolia is a state where the majority of the population itself historically rooted in the territory. This fact has shaped how group identity and rights are understood in law and policy. Demographically, Mongolia is often described as a relatively homogeneous compared to many multi-ethnic states. In a quick view, therefore, the concept of indigenous rights, indigenous people's rights appear difficult to apply to Mongolia. So as a result, Mongolia hasn't developed a formal legal category of indigenous people, and question of the diversity are more commonly addressed through the language of equality, ethnic minorities, culture, and language, rather than through collective territorial lands. Yet this doesn't mean that indigenous type rights questions are absent. Rather, they arise indirectly, especially where the land-based livelihoods, development projects, environmental governance, and service access intersect. So the Mongolia's legal approach to group legal identities. So Mongolia's legal framework is grounded in individual equality before the law, with group identity addressed primarily through recognition of ethnic and national minorities, protection of language, culture, religion, and sectoral laws on education, environment, and heritage. This framework reflects universalist approach. Difference is acknowledged but accommodated within common legal structure rather than through differentiated collective status. Importantly, Mongolia doesn't formally recognize indigenous people as a domestic legal category. Collective land or territorial rights based on customary use or procedural safeguards, such as free, prior, informed consent, as a general legal requirement. So group rights, therefore, tend to be cultural and linguistic rather than territorial or land-based. So the important illustration of Mongolia's approach to group identity is Kazakh nationals, so the left in the presentation photo. Kazakh national minority concentrated primarily in the Bayunguli, the western province of Mongolia, and also present in other regions. Kazakh in Mongolia are settled population within the territory of the Mongolian state with long-standing residence, citizenship, and local administrative structures. Their rights are addressed through minority language, cultural, religious, and equality guarantees, particularly mother tongue education and cultural life. Their situation shows that Mongolia doesn't recognize group identities, but does so through minority rights framework. So internationally, indigenous people's rights are not defined through rigid formula, but through recurring characteristics, self-identification, non-dominance, cultural distinctiveness, and strong relationship between identity and land. These standards can be understood not only as labels, but as functional safeguards designed to protect the communities whose survival and dignity are threatened by the development models that assume sedentarism, standardized services, and uniform land use. This functional understanding is particularly useful for Mongolia. The National Human Rights Commission parliamentary report from 2004 and 2009 on Tsatang or Doha reindeer herding people provide grounded Mongolia-specific evidence. The reports document numerically small mobile community in the western province of Mongolia, and population figures vary across the sources from 114 households, 493 people in early surveys, later counts of about 660, 675 people. And reports reflected the absence of unified baseline study. So this inconsistency itself is significant because for small mobile communities, data invisibility becomes a policy risk. So the socioeconomic findings are stark: high poverty level, limited access to healthcare and insurance, transport and emergency access barriers, and alcohol-related harm and violence affecting women, children, and older persons. The reports also highlight education and language challenges. Tsatan children often grow up in the mixed Tuman Mongolian linguistic environment and enter school with limited Mongolian proficiency, with remoteness and mobility make continuous schooling difficult. Most importantly, the reports emphasize that reindeer herding in the northern taiga region is merely an occupation, but the foundation of livelihood, social organization, knowledge transmission, and cultural identity. So this brings us a crucial analytical distinction. Neither Mongolian traditional nomadic herding, as shown in the west, what's the right side of the presentation. So neither Mongolia's traditional nomadic herding population as a whole, nor the Kazakh national minority neatly fits the definition of indigenous people as it has developed in international law. Nomadic herders largely belong to a dominant national community and have historically been central to state formation. Their current challenges, urbanization, climate stress, and development pressure, are better addressed through rural development, environmental, and socioeconomic policies rather than indigenous people's rights framework. Kazakhs, as noted, are settled national minority whose rights concern center on language, culture, equality, participation, not collective land-based claims. The situation of Tsatang or Doha people, however, is analytically different. They They exhibit several characteristics that align with substantive concern of indigenous rights framework, non-dominance and small population size, cultural and linguistic distinctiveness, livelihood and identity separable from specific ecosystem, and cultural vulnerability under standardized service and development models. In conclusion, Mongolia's legal approach to indigenous rights is best described as non-recognition combined with indirect accommodation through minority rights, equality, and cultural protection. This approach works reasonably for settled minorities as Kazakhs and for the majority population, but it reveals gap when it is applied to small land-dependent, culturally distinct communities. The Tartan case demonstrates that while Mongolia is not an indigenous people's rights context in a classic settler colonial sense, indigenous rights standards remain highly relevant in substance, particularly where identity, land, and livelihood are inseparable. The key analytical takeaway is therefore not about labels or formal recognition, it is about responsiveness, ensuring that equality doesn't collapse into uniformity, and that Mongolia's legal and policy framework can recognize and address distinct forms of vulnerability without undermining national cohesion. Thank you.
Thank you for that presentation. Next, wonderful. So next, we are turning to China, and tonight's speaker is Dr. Phanu Lajadao. I think hopefully I have that pronunciation correct. So Dr. Lajadao is currently Mackenzie Postdoctoral Fellow at the Asia Institute at the University of Melbourne. He's a sociologist of education, focused primarily on the Asia Pacific. His research explores decolonization, multilingual inclusion, and the question of indigenous identity within China. He works to promote educational equity and justice for racial and ethnic minorities and indigenous peoples. I will turn the floor over to Dr. Lajadao, and then we'll look for his presentation. So thank you. Oh, there you go.
Yeah. So I don't have any slides. I'll just provide a short overview of China's legal approach to indigenous rights or group identities and the underlying ideologies. But before I start, I acknowledge the Wurundjeri Woi-Wurrung people of the Kulin Nation as the traditional owners of the unceded land on which I work, and I pay my respects to the elders, past and present. So in China, in 2007, China voted in favor of the United Nations Declaration on the Rights of Indigenous People, or UNDRIP, but denies that it has indigenous peoples. However, this document, UNDRIP, does not provide a fixed definition of indigenous peoples. However, we can find some clues as what kind of people qualify as indigenous people. So for example, Article 3 of the Declaration states that indigenous people have, I quote, the right to self-determination to freely pursue their economic, social, and cultural development. And Article 13 states that, and I quote, the right to revitalize their histories, languages, oral traditions, and philosophies. So Tibetans apparently would qualify these guidelines and norms due to their ties to the Tibetan plateau and their unique language and culture. So I call this type of phenomenon in non-liberal states as indigenous denialism. So the study of this type of phenomenon or indigenous denialism provides a comparative lens to the study of a global indigenous movement in the face of indigenous erasure. As a UN General Assembly declaration, however, these type of documents, such as UNDRIP, are formally non-binding. So, but it does lay out some guidelines and norms with regards to the rights of indigenous peoples. So in China's context, ethnic minority groups such as Tibetans and the Mongolians and the Uyghurs are called Minzu. So this term Minzu is very tricky to translate into English. So originally it was translated as nationalities years ago, and then later it is translated as ethnic groups. And then now in some contexts, it is untranslated. It's just written as Minzu. So for example, in China, there are several Minzu universities. So I remember when I was studying at one of those Minzu universities, when I attended it, the university is called the Southwest University for Nationalities. When I graduate, the university name changed to the English version of the name changed to Southwest Minzu University. So the term Minzu is untranslated. So under the Minzu system, there are designated 55 ethnic minority groups along with the Han ethnic majority. So 55 ethnic minority groups make up of about 8% of the population, and the Han majority are about 92% of the population. So now, as to the underlying ideology in China's ethnic governance, so in China, there's a top-down state policies on ethnic governance and management, and the state-led multiculturalism. So which is governed under a framework of pluralist unity or 多元一体格局, a term which is coined by late Chinese anthropologist and sociologist Fei Xiaotong. So scholars usually attribute this to the scholar, to Fei Xiaotong as the, let's say, archetype type of the ideology. So under this ideology, so all ethnic groups are treated as equals, and they are different, distinct ethnic groups, but they are also one body of 中华民族 or Chinese nation. So more recently, some scholars such as Ma Rong, who is a very prominent professor at the Peking University, and he's by the way, he was educated in the trained in the U.S. at Brown University, so he has the context of he knows the context of both the West and the East in terms of its approach to racial and ethnic issues. So he has participated in a very wide online and scholarly discussion called the second generation Minzu policy. So this second generation Minzu policy advocates for this depoliticization of Minzu identities. In Chinese, it's called 去政治化. Instead, these scholars would advocate or propose this culturalization of ethnic identity, meaning that we should emphasize the cultural markers of ethnic identities and to de-emphasize their political group identities and the rights and other kind of entitlement that are associated with this group identity. So why China denies the indigenous status of these ethnic minorities? Well, there's this Harvard historian called Mark Elliott. He has a very good article on the China Journal in which he attributes to an article which is titled as the missing indigene in the China's ethnic debates. So he calls that. So first, there's this fear that by emphasizing the indigenous identity of these ethnic groups, then that would incite or let's say give incentives to the quote-unquote separatist movement. And so this gives a rise to this consciousness of unique ethnic or nationalities of these groups. And the second, by acknowledging the indigenous status of these ethnic minority groups, that would invite UN general, the delegations and the rapporteurs and other human rights groups to come to Tibet and to Inner Mongolia to inspect the human rights conditions of these ethnic groups. And China apparently doesn't want that. So that's why these are the apparent, let's say, incentives or the reasons behind this indigenous denialism. And China often calls its ethnic governance as internal affairs and doesn't want any of the human rights groups making any comments on these issues. So more recently, since around, let's say, a decade or so ago, there's also this guiding principle of 中华民族共同体意识, which translates as this common consciousness of a Chinese nation. 中华民族 means Chinese people or Chinese nation. But under this guiding principle, there's an emphasis on the homogeneity of the ethnic groups. So yes, you are Tibetan, you are Mongolian, you are Uyghur, but after all, you are all Chinese nation. You are one people. And so there's this emphasis on the homogeneity, and also this de-emphasize, or let's say, let's de-emphasize on the heterogeneity of the unique status and the rights and the language and cultures of ethnic minority groups. However, even though there's indigenous denialism, but every country, the context of each country is different. And in China, it doesn't mean that ethnic minority languages and their cultures are wiped out, or there's this very intensified assimilation efforts. In the opposite, in my research, I have written papers on this state-led multiculturalism, which in a summary, which can be summarized as there's this multiculturalism and multilingualism in China that is happening, but that has to be led by the state, governed by the state, and in the form of the multiculturalism that the state wants. However, if you want to emphasize something out of this, the legal, or this, let's say, this ethnic, this system or framework, then there will be consequences. There will be, let's say, punishment for those individuals who are advocating for these. So that's why in China, this indigenous denialism is governed by also this colorblind ideology. Basically, to those who are unfamiliar with the China's context, that is, we don't judge people by their identities or the way they speak and they think. Rather, they are all one people. However, by doing so, all their group rights are in some cases are compromised, and there are implications on the rights to education and their participation in the labor market and the other forms of their civil life. So that's my presentation. Thank you.
Thank you. And thanks to all the speakers for the very fascinating presentations. I'm now going to turn over to the questions from the audience, and then I also have questions as well. So I think we have enough time for one round of questions, and then after then we will have closing comments from all the speakers. But I will start. There's one question from the audience. This is Pascal Rosier from LexisNexis Tokyo. And this question is for Dr. Uzawa and Dr. Osakada. This is about the bears. And so currently Japan has adopted a very aggressive approach towards bears in the country. And there's been frequent or increasing news reports about the police and hunters attacking or killing the bears. Bears are significant in Ainu culture. And so Pascal is asking specifically from an Ainu perspective, an Ainu ancestral standpoint, what is the Ainu position about the current treatment of bears in Japan? And is there Ainu ecological knowledge that would guide Japan in terms of its treatment of bears right now? So I'll open that question for both Dr. Uzawa and Dr. Osakada, and either one or both of you can answer that question. Before you do, let me just give the questions for Nara and Laja. So Nara, I have a question regarding Mongolia. So for tonight, your presentation was about Mongolia specifically and the peoples within Mongolia. But some indigenous communities, they cross the borders, or the culture crosses the borders into other countries. And so I'm curious if Mongolia has had conversations with Russia or China about these transboundary movements, or if this has been a point of discussion in any of the considerations of the minorities that are in the country. And then for Laja regarding China, this is the last question. There is this tension between the need for minorities to have distinctive identities, right? So, part of the goal of indigenous rights is to have a distinctive culture. But then at the same time, you describe this state-driven or state-led multiculturalism. So I guess the question is, do minorities actually have the ability to participate in state-led multiculturalism? Are there minority guarantees of participation within the Chinese state or within the Chinese Communist Party? So I think those are the questions for all of you. So let's go back to the first question regarding Japan. So Dr. Osakata, Dr. Uzawa, feel free to answer.
Yeah, I'm sorry, but I don't have an heritage, so I refrain from answering this kind of question about an perspective. So maybe Kanako-san will answer this question better.
Yes. So when it comes to bear, it has been yes, it has been a lot discussed this year, particularly. But we have a concept called IOR, which is the community where we create a space, and that's corresponding to the harmony, living together, coexisting with nature and animals. So there is a project actually on restoring a forest, because those bears can't find the nuts that they usually can find in the forest, and that's why they're coming to town to look for a food. And once they taste the human food yes, so we are trying to. The short answer is that we are trying to restore the forestry around the regions, so that the animal, including bear, can start finding more balance in nature.
Thank you. And then Nara, did you have a comment about the question I had?
That's a kind of thought-provoking question. But definitely, of course, because of this legacy of Mongol Empire, and there is a huge cultural influence from the Mongolia to the Mongol nationals in China and Russia. And of course, if there is a kind of the ethnic-related concerns happen, the Mongolia, the state of Mongolia, approach to Russia and China formally, but it's not very much publicized. So there are very strong cultural ties with the Inner Mongolians, and also the Buryat Mongolians and other ethnic Mongols in Russia.
Thank you. And then Laja,
yes. So as for the degree of participation of Tibetans in the state-led multiculturalism and ethnic policies, so in China, Tibetans and other let's say ethnic minorities with a certain degree of population live in these zones or places that are known as autonomous prefectures or autonomous regions, and in some cases autonomous counties. So in this, let's say in a Tibetan autonomous region, or TAR, which is now officially called Xizang in China's official narratives, they are constitutionally granted the rights to self-determination, to use their language, culture, and to advocate for their, let's say, group rights. However, in reality, there's certainly some restrictions. But I think in most of the cases, there are still bilingual schools and mother tongue-based education, at least at the elementary school level. And I think, broadly speaking, I think what China really fears is not this promotion of multiculturalism or multilingualism, but rather this assertion of their group identities and group rights, so that it will give rise to all forms of, let's say, tensions in these ethnic relations. So yeah. So to simply put, I think there is a certain degree of participation, but I think the degree to which they can participate is often depend on the context and also restricted.
Mhm. Mhm. All right. So now we are approaching the close of the webinar, and this is the time when we ask speakers for closing comments, final thoughts, and if there's any messages that you want to convey to the audience. And it's not just the audience that's here, but the audience that is watching once we place this on the YouTube channel. And so essentially the larger world. So, feel free to state any points that we did not address tonight, or any concerns that you want everyone to know before we wrap up for the day. So I will begin with Dr. Uzawa, and allow you the time for a closing comment.
Thank you so much, Jonathan. I think it's a very valuable webinar, to be able to speak about East Asia, which often not so much focused or many people are not aware of. So I appreciate this opportunity for me to speak about the Ainu, and also interesting to hear the other presenters' discussions, and especially the discussion like a concept of understanding collective rights versus individual rights, and that has been also discussion within the Ainu and within the context of Japan. The awareness of human rights or indigenous rights has not been taught even in the school education. So it's something that we are trying to work on. So thank you very much for this opportunity once again.
All right, thank you. And then Dr. Osakata, do you have a final comment?
Yeah, okay. Thank you for having me today. And thank you other panelists for your wonderful presentations. And Jonathan, thank you for organizing this meaningful webinar again. And yeah, as I mentioned, I do not have indigenous roots myself. And so it is a sometimes difficult question how I should be involved in movements to restore indigenous rights. In the case of Ainu in particular, there are many issues on which opinions are divided within Ainu communities, which makes involvement even more complicated. However, I do not think that a disagreement with the indigenous communities means that nothing can be done. From another perspective, movements for indigenous rights are also about how colonizers address and redress colonization as an ongoing process, not just a past event. So, as someone on the side of colonizers, I believe it is necessary to engage actively and responsibly in working to redress and resolve this continuing legacy of colonialism. Of course, in collaboration with indigenous peoples. Thank you so much.
Thank you. Next, Dr. Ganbot, do you have a closing comment?
Well, so thank you very much for this opportunity to share my view, and I hope the Mongolian case contributed a bit more nuanced understanding of how indigenous rights discourse can arise in not a very classic colonial settler setting. So I learned a lot from my co-presenters, and thank you very much all. It's such a great pleasure to know you and like this session. So I think that's all from me.
Yeah, thank you. And then last, we'll have Dr. Laja. Did you have a closing comment?
Oh, thank you. I want to thank you for organizing this event, and thank you for all my all panelists. I also learned a lot from the other panelists, and also this presentation is also very personal to me because as the ethnic minority of Tibetan heritage, I think it really feels deeply to talk about these topics. So thank you.
So thanks once again to all of the speakers. We're very grateful for the time and interest that you provided to us. This is something that, it's not just you, but it's also all of the speakers we have in this webinar series that we're trying to elevate Indigenous voices to a larger audience. And so this is part of a larger mission. So we're very grateful for your contributions. We're very grateful for the audience for attending, and not just the ones here, but also the ones who are watching on the YouTube channel. And for anyone who's watching, the main focus that if you want to learn more, there are ample opportunities and resources regarding Indigenous rights, Indigenous peoples. We would ask that whenever possible, you do try to look for Indigenous sources. So these are sources that are been published and issued by Indigenous scholars, Indigenous experts, Indigenous people specifically, so that they are speaking about themselves. And there's that phrase, "Nothing about us without us." And so it's important to actually listen to an Indigenous person talking about their own culture directly. I'll make a final note that going forward, we are continuing this webinar series. So we would ask that the audience please look for the next webinars. We will continue the progression of webinars on Indigenous rights within the Asia Pacific, and we will make announcements for those in the coming months. But in terms of tonight, we're now a little bit over time, so I just want to make a final goodbye. Thank you once again to the speakers, and good night, everyone. Thank you.